Hello there. Welcome back. Today we're going to be talking about um, a concept that is becoming very, very large in the business/legal world because of its heightened efficiency and cost benefits as opposed to settling disputes in court. What we are talking about, in other words, are alternative tools of dispute resolution. In other words, let's work out our problems without spending tons of money and time on lawyers and court and all of that good stuff. So today we will be talking about negotiating and settlement, mediation, arbitration, mini trials, early neutral case evaluation, and private trials, as well as summary jury trials, court-annexed alternative dispute resolution, the future of alternative dispute resolution, and of course the global dimensions of alternative dispute resolution. Alternative dispute resolution is more commonly known as ADR. This is resolving legal disputes through methods other than litigation or going to court. And again, here are some of the ways that you can go about this listed: negotiation and settlement, mediation, arbitration, mini trials, early neutral case evaluation, private trials, or summary jury trials. And here are some very nice advantages of using ADR over litigation or going to court. It can be less expensive. There are no court costs, filing fees, blah, blah, blah. Lawyers charging you hundreds of dollars per hour to work on your case. The costs can be considerably less than going the conventional court routine. Convenient and less time consuming. You don't have to get on a court's calendar, which can take months and months. You're more open to be able to set times, meetings and times at your convenience, when you're able to meet, where you're able to meet, as opposed to trying to fit yourself into a court schedule. You have the freedom to choose your own experts. They don't necessarily have to be certified experts by the court. This preserves confidentiality between parties as well, because this is private, whereas court cases are a matter of public record. Cases can be resolved without a precedent being set. Maybe you want to do things a certain way just for this one time, but because of some sort of extenuating circumstances, but you don't want to make it a standard practice. Well, if you take the matter to court and have a court decide the outcome, whatever that outcome will now be the standard practice, because similar cases arise again and end up in court. The court will be bound to follow the case that you set up. And you may not want that in the future. This also helps to preserve a good relationship between the parties. You may be in a long-term contract to do business with another party when the dispute arises. And rather than have a totally ugly, nasty relationship for the remainder of your contract, this is an easier, less, what do I want to say, not quite as harsh way of doing things. You have a much better opportunity to preserve a decent working relationship with the other party by going through ADR. The first thing that happens when we're talking about trying to settle a matter out of court, ADR, is negotiation and settlement. This is where the disputant parties informally try and resolve their differences. We are still at the old we can work it out stage. Requires each party to give up something in exchange for getting something from the other side. Lawyers do this before taking a case to trial or opting for more formal methods of dispute resolution. This is basically an informal meeting, a phone call, dinner, whatever, where you say, look, we have this dispute here. I don't want to go to court. You don't want to go to court. Can we compromise? Can we work this out? Bearing in mind the fact, of course, that compromise means nobody walks away completely happy or unhappy, either one. By far and away the most advantageous way to go if it is at all possible. But if not, the next step up the ladder is mediation. This is where the parties select an expert in the disputed area to help reconcile their differences. The goal is to initiate communication between the parties, help the parties find an agreeable solution, and provide a resolution that is fair, equitable, and based upon sufficient information. The mediator basically is a fact finder. His or her job is to get the complete story, if possible, from both sides. Look at both stories and decide to make recommendations that are in the best interests of both parties as much as possible. Mediation is used for a lot of things: collective bargaining disputes, unions, insurance claim disputes. When claimants and insurance companies are haggling over the value of a claim. Commercial contract problems, breach of contract, unfair competition, failure to deliver products, employment disputes. Sometimes at-will employment isn't exactly always at will, especially if you're talking about people with highly sophisticated, highly technical expertise. Salespeople. Salespeople cultivate relationships with their clients. And when they leave or are asked to leave a position, there's a problem with what happens with that person's client list, which can cause employment disputes. Environmental disputes. Companies that are improperly storing hazardous materials or improperly discarding waste. Rather than go to court, let's come up with an equitable solution that will bring the company into compliance without having to drag them into court. Okay. As is the case with most anything and everything in life, there are advantages and disadvantages to mediation. The advantages are, as we said, preserving a relationship between parties. Many times you're in a long-term relationship with whoever it is you are having a dispute with. And it's to everybody's benefit to keep that relationship. as civil, professional, and cordial as possible. Promotes better understanding of each other's positions. You each have your say. Offers potential creative solutions. Kick things around, brainstorming. That doesn't typically happen in a courtroom setting. It's not as adversarial, it's less expensive, and it's less time consuming because you're not dealing with courts and court calendars and lawyers. There are some disadvantages, however. Can't overlook fundamental structural conflicts. If there's something at the core of the working relationship that is wrong and transcends this dispute and goes all the way across the relationship, perhaps ADR is not going to be that helpful. Gives misleading impression of equality of parties, which may not always be true. May be subjected to abuse by a party who believes that he or she will ultimately win the dispute. Look, if this ends up in court, I'm going to win. So this is going down my way. Oh, really? You just lost the purpose of ADR entirely. Okay, so we've gone to dinner and tried to settle our differences amongst ourselves. That didn't work. We've had a mediator come in and try and provide us with some creative solutions to our dispute. That didn't work. We take another step up the ladder. We are now at arbitration. Disputing parties submit their disagreement to a mutually agreed upon neutral decision maker or one provided for by statute. The arbitrator actively questions witnesses. There are briefs written by the parties. These are arguments in favor of their position that the arbitrator reads and reviews. And then the arbitrator is the one who decides who comes out on top. Binding arbitration means you are going to abide by whatever the arbitrator decides. And courts typically enforce those awards. Proceedings are private. There are witnesses and evidence produced in arbitration. Decisions are usually rendered within 30 days and are typically a compromise between the two positions. The reasons for the compromising nature of an arbitrator's decision were not in court. Arbitrators are not constrained by precedent. They don't have to follow court decisions from their jurisdiction. They can fashion an outcome however they see fit. We are still trying to maintain an ongoing relationship between the parties, although it's getting a little harder. It aims at maintaining a reputation for being fair to both sides. An independent, neutral party. There can, however, be grounds on which an arbitrator's award is set aside. If the award was the result of corruption, fraud, or other undue means, meaning if the arbitrator exhibited bias or corruption and refused to postpone the hearing despite sufficient reason to do so, if he heard evidence or material pertinent to the dispute or acted to prejudice the rights of one party, if they exceeded or failed to use authority to make a mutual, final, and definite award. You must investigate thoroughly. You must get all the facts. You must render a neutral decision. How can you go about securing arbitration? Binding arbitration. That means all disputes arising under the contract be settled by arbitration. You can have this built into any contract. A contract to do business. A contract to form a partnership. A sales contract. Any disputes that arise shall be submitted to binding arbitration. That can be part of the general contract. Submission agreement. Separate agreement providing that a specific dispute will be resolved through arbitration. That's a specific dispute, not any and all disputes that may arise during the course of a contract. Here is a checklist for drafting a mandatory arbitration clause. You can read through those. At your leisure. We have a case in this chapter, the American Express Company versus Italian Colors Restaurant. American Express, the credit card folks, entered into an agreement with merchants who accept their credit cards. Merchants filed a class action suit on the grounds that American Express violated Section 1 of the Sherman Act and in turn sought damages under Section 4 of the Clayton Act. So a whole bunch of people, business owners who accepted American Express as a form of payment, felt that American Express was not doing right by them and got together and filed suit. The district court granted the motion, therefore dismissing the lawsuits, but the Second Circuit Court of Appeals, try that, reversed the decision. The reversal was due to the prohibitive costs that the respondents would incur, and since class action waiver was not enforceable, arbitration could not occur. Read that case more thoroughly and we will talk about it in class. Selecting an arbitrator. You select an arbitrator on the basis of their special expertise in a particular field. Some places to go looking for arbitrators: the American Arbitration Association, the Federal Mediation and Conciliation Services. Parties and the arbitrator select the date and time and place that the arbitration will occur. There is a code of ethics for arbitrators. They must uphold the integrity and fairness of the arbitration process. They must disclose any interest or relationship that is likely to affect their impartiality or that might create an appearance of partiality or bias. May not be any, but even if it appears that there might be, not good. Avoid impropriety or the appearance of it when communicating with the parties. Even the appearance of wrongdoing, even if it has not been proven, is unacceptable ethically. Arbitrators must conduct the proceedings fairly and diligently. They must make their decisions in a just, independent, and deliberate manner. They must be faithful to the relationship of trust and confidentiality that comes with that position. In a case where there is a board of arbitrators, each party may select an arbitrator. That arbitrator must ensure that he or she is aware of the ethical considerations in the type of situation being posed. Where do we use arbitration typically? Well, labor disputes, salaries, business conflicts, consumer complaints, technological disputes, and employment disputes. Okay? Problem with arbitration. They may lack expertise in discrimination matters because discrimination has a legal ring to it. Compulsory arbitration in employment and termination cases erodes workers' rights. If part of your condition of employment is you are forced into arbitration should a dispute arise without having your opportunity to go to court, it's kind of taking away your rights. There are concerns with arbitrators' non-legal background, like the discrimination matters, and there are no written opinions because these aren't court cases. They are privately settled disputes. Some less common ways of handling disputes, besides mediation and arbitration, are things like mini trials. Lawyers for each side present the case at a proceeding which is refereed by a neutral advisor. The actual settlement authority lies with the senior executives of the disputing corporations. The neutral advisor settles the case if the corporate executives cannot resolve the dispute within a given period of time. Okay. So basically everybody's getting a little preview of what might happen in an actual bona fide court of law, should this dispute make it that far. Makes the side who comes out not looking so good much more willing to talk about other options. Private trials. You can do that. Cases are tried in private by a referee who is selected by the disputants and empowered by the statute to enter a binding judgment. The referee states his findings in a report that is filed with the trial court. The criticism here is private trials could lead to a development of a two-tiered justice system, a traditional public system and a private system. Well, then you're ending up with conflicting outcomes, and if you go privately, you might end up with one verdict, whereas if you'd gone publicly, it might be completely different. You have to have a unified system of justice here. A summary jury trial. This is an abbreviated trial, a non-binding jury verdict, and a settlement conference. Again, this lends itself towards, okay, here's a preview of the coming attractions, ladies and gentlemen. The side that's not looking so good, you want to talk? Okay. Court annexed ADR. Courts may mandate that disputants go through some formal ADR process before the case sees a courtroom. The requirements vary from state to state and in federal court, but it is non-binding, and there are courts and judges that say before you are in front of me, you must try ADR. The differences between court required and voluntary ADR. Court required, the outcome is not binding, and the rules of evidence are flexible. If you go to voluntary arbitration, the outcome is binding on both parties, and you can't mess with the rule of evidence. Seems interesting. You would think it would be the opposite, but it's not. I suppose because if you are being court mandated to go to ADR, it's kind of messing with your rights a little bit. So they, in exchange, give you a little more flexibility. Court annex, parties enter into the mediation process, viewing it as a hurdle to go through before the trial. Basically, yes. Voluntary parties enter into the mediation process with a desire to work out an agreement. Yeah. In the voluntary process, you're hoping to avoid seeing the courtroom. Criticisms against ADR. Dispute resolution cannot be unbiased when one of the parties of the dispute is a major client of the dispute resolution provider. Well, you wouldn't want to do that. Consumers are forced to give up their right to a trial when they are likely to get a higher award from the jury. They're coerced to agree to arbitration because they failed to read a clause in a purchase agreement. Oh my. Right. If you've agreed to dispute settlement via mediation or arbitration, binding arbitration, you give up a lot of rights in order to avoid court. Sometimes that it's okay, other times it's not. Like if you could get a higher award from a jury, you've given up your right to do that. Okay. Our objectives covered were negotiation and settlement. You see us walking up the ladder here. Mediation, arbitration, mini trials, early neutral case evaluation, private trials, summary jury trials, court annexed ADR, future of ADR. Well, it's the thing now. I would be so bold as to say that in both the criminal area and the civil area, somewhere in the general neighborhood of 90% of cases never see the inside of a courtroom. Criminal trials, a deal is worked out. Civil disputes, they're settled via any one of the methods we've just been through here. Anywhere from negotiating to ADR. So it is the way of the world. And as far as global dimensions of ADR, if you're doing business with other countries, you need to make sure that you have it be in your contract that where any disputes that may arise, where those are going to be settled, in what country, by what method. Again, it is a world business place. It is not a United States business place. It is not a state business place. So, there you have ADR, and we will do some work on that in class. Have a great rest of your day, and we will see you soon.